Welcome back to Sunrise. The Ministry of Legal and Constitutional Affairs will be championing a number of efforts to engage with the public and partner with stakeholders to provide information on the new Bail Act in the coming months. Joining us this morning is Legal Education Officer at the Ministry of Legal and Constitutional Affairs, Mr. Ivan Godfrey.
Morning.
Welcome to Sunrise.
Morning, Ivan. How are you doing?
I'm doing well. Thank you for having us.
First of all, congratulations for there being a legal education officer.
Yes.
Because the truth is that law is a technical area and the average person does not understand. And sometimes we ask questions that seem simple or simplistic to the trained legal mind when actually, you know, it is a very difficult thing to comprehend.
Yes,
First question I have, in terms of the new Bail Act, there's always mischief that a new law is seeking to remedy and prevent. What is this new Bail Act seeking to do that the previous one didn't?
Well, from as early as perhaps a few years after the last act was passed, I believe in 2000, there were calls for reformation to the legislation. And I believe after 23 years of the legislation being in place, nuances and things, mischiefs would come up that would have to be remedied. One such very important one which the act deals with is pre-charge bail,
Yes.
which are circumstances where persons are detained but not charged with offense. So that's essentially one of the big ticket items that legislation deals with.
You know, let me ask this. A question came in, and I'm going to read it down. My name is Derek. I'm writing a paper on how the new Bail Act will affect the flow of persons through the judicial system. Please help me understand what are the main changes and how it benefits us as citizens of Jamaica.
Well, I like to say that the legislation has something for everyone. So it has now dealt with bail in 3 phases. The first phase is circumstances where a person has been detained by the police, arrested and detained, but has not yet been charged for an offense. The second one, which we all know about, is circumstances where a person has been charged. And then the third one, which a lot of people don't know about, but probably do know, is circumstances where a person has been convicted of the offense. However, bail is still available to them in circumstances where, up to the point of their sentence, conviction and sentence, they were previously on bail, and in circumstances where they're now seeking to appeal the sentence.
So again, these are 3 important areas.
Yes.
I think that the public discussion has largely surrounded pre-charge bail. It was a very prickly issue. How has the Bail Act sought to navigate those prickles?
All right, so in a previous life before I was legal education officer, I was a clerk of the court.
Okay.
Across several parishes as well. And you'd see circumstances where sometimes the police come in with what is called a remand book, and they're asking the judge to remand the person, for a particular number of days because they have, this amount of investigation to do and so on. Or you could also go to a justice of the peace and ask to remand a person for a further period. So there really was no certainty in terms of what the legal position was. So the legislation has now come into place to ensure that there are strict timelines in terms of when you can, for how long you can detain a person, and also the procedures that are to be followed. So for example, what the legislation says is that within 48 hours of the person's detention on pre-charge bail, in circumstances where they haven't been charged, the question of bail is to arise. Now, it also understands and contemplates that there really are some things that cannot be done in 2 days. So in circumstances where a person is needed for an identification parade, the legislation says that that person can be held for up to 120 hours for the identification parade to be done, because there are certain places in the country that do the parades and so on. So it does put strict timelines into place for how long a person can be detained. Further to that, what it says, so the legislation has created what is called a deciding official. And a deciding official is the person who can grant or not grant bail.
And who is that?
Now, at the pre-charge stage, the deciding official is a justice of the peace, or a police officer at the rank of superintendent or above. In circumstances where the justice of the peace or the concept at the rank of superintendent or above has decided not to grant bail, then the matter has to go before a judge for the judge to decide whether, on the grounds, he or she will grant or revoke bail. Sorry, or not grant bail. And in circumstances where bail is not granted, they are also to stipulate a point in time for the person to be brought back for the question of bail to arise again.
All right.
Is this increased protection of the innocent or not?
So I believe it's increased protection for everyone because we have to understand that under our legal dispensation, there is a presumption of innocence. And what that means is that a person is innocent until they've been proven guilty by a competent court. And further to that, what the legislation says at Section 4, and is also enshrined in our Constitution in the Charter of Fundamental Rights and Freedoms, is that persons have an entitlement to bail. So really the starting position is that the person should be granted bail, and thereafter the prosecutorial authority or the prosecutor has to show circumstances why the person should not be granted bail in all the circumstances.
Indeed.
So I believe it really does protect everyone in the grand scheme of things.
Yes,
Indeed,
yes,
quite so.
A three-pronged approach now to the prior two approaches. Post and at charge, now pre-charge is included. Our guest, Ivan Godfrey, Legal Education Officer at the Ministry of Legal and Constitutional Affairs, came and enlightened us. So more on Sunrise on the other side of this break. Stick and stay to Sunrise.